Okay. There we go. All right. All right. I remember to start the recording at the beginning this time. So welcome everybody to round 2 of the paralegal, legal secretary, and office support staff work group. We're going to pick up largely where we left off last Friday. Did everybody have a chance to look over the draft that I sent yesterday afternoon? Okay, cool. I've incorporated some of the feedback from Amanda, and I think where we're at now, role definitions are pretty good for office support staff. I took some, so that everybody knows where some of this language came from. The 6-year plan, which apparently is still only in draft form, but the draft that we have now, had some specifically identified tasks that were anticipated as ways other support staff roles, other core staff roles could free up attorney time. So I went ahead and pulled some of that information, some of those tasks, and assigned them to different levels within the classification that we put together. The big, hold on, yeah. I think I had some questions though for the group as to whether some of these got classified right. So first, discovery redaction. Do we feel like that's something that someone who doesn't have at least a legal secretary can do? I think we had in the office that I was in, the attorneys would mark things for redaction. So I would imagine we want at least some level of oversight, which is why I'm not sure it was appropriate to put in that lowest tier.
I can maybe add to that. So
sure.
Over in the appellate division, the legal assistants, I'm a legal assistant, we redact everything. So I don't know if that helps as far as putting it in that level, or if you're wanting to know if we should put it in the office support staff level.
I mean, I'm totally cool with moving it all the way up to paralegal, legal assistant, because that, I mean, that especially if it's somebody who's doing it with not as attorney directed, but as like somebody using their own like decision making. I feel like that is almost certainly not somebody I would want at the entry level doing.
Yes.
Okay.
That's right.
I go back to my previous comment about entry level, being 18, just the sensitivity of it. So I think the secretarial level.
Oh, good point. Okay.
And in our office, Kevin, at Arneson, the attorneys actually still do their own redactions, although as a legal assistant, I would feel comfortable doing it.
Okay. And Sarah, you had some comments. Amanda, I apologize. You'd had some comments about the terminology. When we met last week, we broke into 3 tiers, the lowest tier being general office support staff, which could cover a whole wide range of roles like clerks, like administrative clerks, receptionists, other kind of entry-level task support, and then a middle tier of legal secretary having some experience, but not necessarily a huge amount of training, and then the higher tier of paralegal or legal assistant. Since those terms appear to be fairly synonymous within the community at this point, those are now.
So can I just say something? I guess.
Sure.
So just in my impression, and I guess I don't know what the origin is or what the support is for saying that a paralegal and a legal assistant are synonymous. I had thought that a legal secretary and a legal assistant were synonymous, and paralegal was a different classification. And I have had the experience working for both the state and federal government where legal assistants really do not like to be called legal secretaries. that's kind of a, you know, a outdated term, and that they prefer to be called legal assistants, and paralegals don't like to be called legal assistants because they are very much, you know, a different classification that has more skills or experience or education. So that, and I don't know, I'm really new to the defense culture, but I can tell you at Oregon Department of Justice and at the U.S. Attorney's Office, you would be in trouble if you referred to somebody as a legal secretary, or if you referred to a paralegal as a legal assistant. So that's just why I raised that issue.
I'm going to throw that back to the group. Bobby, looks like you've got your hand up.
Oops, clicked the wrong button there. My question was actually unrelated to that. So if we want to finish up this topic.
Yeah.
Yeah.
So that was my understanding based, this was something that we had discussed last week based in part off of NALA's guidelines, and brought up, hold on, let me see if I can pull, where they describe the two, paralegal and legal assistant, as being synonymous. What is the consensus, if there is some, for the rest of the group? I know that's what we had come up with last week. We have different feedback now.
Yeah, so I work primarily in juvenile law, both delinquency and dependency. We absolutely use paralegal and legal assistant interchangeably. I've never heard legal secretary used to describe literally anyone. We'll often hear trial assistant as well. But I would say, yeah, in juvenile, those are interchangeable. Paralegal and legal assistant are interchangeable.
I would back that up as well over here. We actually, the titles are different, the pay scales are different, but the tasks are completely interchangeable. We have the same skill sets pretty much. I do know, like in our, like the appellate side, that's how, like, we could do the same, you know, same tasks, same filing, same everything. But I know that maybe in a different agency, that might not be the case. A paralegal may be allowed to handle more as far as drafting goes. But in our side of the agency, the paralegal and legal assistant are completely interchangeable. And we haven't used the term legal secretary in a very long time.
Okay. The firm that I was... Okay, sorry, go ahead, Beth. No, you're good.
It's same here at private practice at Arneson. We use legal assistant, paralegal interchangeably, and we actually use legal secretary to define what was traditionally a receptionist position. Oh. So in addition to answering the phone, she does other responsibilities. So we have now defined that as a legal secretary.
So I will note that the way I had thought our framework was looking at previously is that the lowest tier, what are classified as office support staff, that was intended to cover a very broad range of people who might have other experience and other things that they're bringing to the table outside of like the legal support and direct administrative, well, the legal support side really. And there may very well be offices that don't end up having anybody in that first category because everybody's also got other jobs assigned that would qualify for the middle or lower or the higher tier. I'm hearing feedback about legal secretary being used, but also potentially carrying some connotations that are less ideal in this day and age. Part of what we can do here is we can define the title that we want, if that's the way we want to go. And that's with the limitation of, if the industry standard is that paralegal and legal assistant are considered synonymous, I would like not to break that current industry standard, if that makes sense, because I don't want us to like completely shy away from the rest of the field and forge a path that may cause confusion where otherwise there wouldn't be any.
What I heard Amy say was that exactly what I said, which is that they use legal assistant to mean what you are saying a legal secretary is in the document, but that legal assistants are in a different classification and paid less, but in practice they do the same things as paralegals. They're interchangeable in her office. And I think that's consistent with what I'm saying and what the guidelines say, which is at the top, the guidelines say you can use a paralegal or in this document, a legal secretary to do both of these things. But this is the way that they're categorized in terms of payment. And that's exactly how I would say it works in my office. And I agree with Bobby because I also do juvenile dependency stuff, and that people use those terms interchangeably, partly like I have somebody who hasn't been to paralegal school and she's not certified as a paralegal. So I always feel like it's more accurate to call her a legal assistant, but I use her the way other offices would use a paralegal, just based on my understanding of what her skill set is. I just think and I just, by the way, Googled it. And I mean, just common usage nationwide, it's legal assistant is legal secretary. What we used to say is legal secretary, and paralegal is what we've always meant. So I just think it makes it cleaner, and especially since we're going to be using them to do the same things, that's clear in the document, that is just, in terms of the language, an easy way to do it, and the document will define those different levels, but it doesn't mean that you can't use legal assistants to do what are described as paralegal duties and vice versa, if that's what works in your office.
Bobby?
I want to back up a little bit just because I missed the first work group. And so is the point of this document and these definitions to be for OPDC when they open state offices or when people are becoming, or is it for all private contracted roles, including?
It is intended. Yeah, no worries. So, yes. So these are not just for OPDC's use internally. This is intended far broader for anyone. So the kind of the where of how this came about, the Moss Adams did a 6-year strategic plan for us that includes, as a component, shifting work that should be done by other core staff members away from attorneys. We want to be able to compensate those roles as part of the public defense work writ broadly, not just internal to OPDC, but through contractors, through hourly attorneys. We want people to be able to access these core staff support services, and have them funded more directly, as opposed to just calling it overhead. And to do that, we need the commission to approve practice performance standards, qualification standards, so that we can ask the legislature for the funding to move those tasks to non-attorneys.
So is the idea then that like funding will be, okay, for every 1.0 MAC, you get a 1.0 paralegal and a 0.5 legal assistant, like hypothetically?
I think the staffing ratios are, I think they're a longer term question, not what we're looking at right now, but yes, yeah. that would be something that we'd also be looking at. I know like last year we did some work, but it never ended up being. So last year we did develop training and supervision standards similar to this. I mean, obviously that's still attorney work, so it's outside the core staff role, but and that did include staffing ratios for supervisors and trainers. This would, yes, eventually I think we would be looking at those as well, but that for right now, what we're looking at is just, what do we need to know someone in order to say that we should fund someone? What do we need to know about them to say they're qualified? And once we are funding them, what are we expecting them to do? So both they and we know this is what we're paying for. Well, what the legislature's paying for.
That's helpful because I don't think there's ever going to be a consensus among every office in all of Oregon to say like, oh, well, is this person a legal assistant or a paralegal? And you're like, I thought they were the same. Like, yeah. And, you know, particularly if you have like the old guard attorneys who's like, well, this is my legal secretary. And you're like, but I draft all your motions. Like, you know,
yeah.
Okay, so that's helpful to have some context of what exactly we're doing and why. So thank you.
And the broad framework for the 3-tier was the lowest tier is purely administrative work. Middle tier is a mix of legal and administrative, probably slightly more administrative than legal, but routine legal stuff. And then the paralegal classification is, no, you're doing a lot more legal work than administrative stuff. Okay.
One feedback comment that I did have in looking at somebody else's comments of like the requirements in those bullet points was having a bachelor's degree for being a paralegal. And I felt myself get a little bit prickly about that because we practice quite a lot of juvenile in a lot of rural counties. And so if somebody is defined as a paralegal out in, say, Malheur County, but doesn't have a bachelor's, are we then like stripping them of that title or that funding? And that potential career trajectory if they're not able to have on their resume or their footer or contact or business card or whatever because they didn't have a bachelor's. Like I wouldn't want to see that sort of.
No, I hear you.
Yeah.
So the intent, and let me scroll down, was that each of those qualification options is completely separate. You just have to meet one of those 7. I've gone ahead and gotten rid of both of, excuse me, sub option things. So it's now just, so for that, it would be bachelor's in a field and 6 months of in-house training is one of the ways to certify. But any of the other 6 would also work. We don't necessarily need it to be, yes, this is in addition to other things. No, this is one of the 7 ways to be qualified. And I will say this is ripped directly from NALA, and we may absolutely say, now we want a completely different set of qualifications. I just threw these in as a kind of a placeholder until we'd actually had this discussion.
Okay, yeah, I understand. I just wanted to give my feedback on that portion. And then have we defined what in-house training is or would be?
We have not.
Cool.
So, okay. So what I'm hearing is what is the consensus, if it exists, about changing this and removing do we want to change that middle tier to legal assistant and have the top tier solely be called paralegal? Okay, Dawn, I see you're nodding as well.
I am, but again, I'm not, I run an investigation agency, so
right.
I'm legal support, so.
Beth, I know you were involved last week as well. Did you have any further comment on there?
We use legal assistant and paralegal interchangeably here, but personally, I think they are different things. I was certified in the state of Georgia before I moved to Oregon, and it was definitely a different classification there. But like I said, here at Arneson, we use them interchangeably. So I'm fine with either way.
And I will say, like, we're not necessarily intending that anybody lose the ability to call themselves things. This may be just what we, for funding purposes, call these different stages. I will say that I think, and I put a marker towards this later on, one of the things just being to clarify, anybody in any of these roles needs to be really clear they're not an attorney and they are not, like, that they have a limitation on what they're able to do from that. But ultimately, if somebody wants to call themselves a legal secretary, I don't think we have the power to say, no, you can't do that. But from our funding perspective, we may need to classify, okay, which of these 3 are you saying that you are? And it may ultimately be other office support staff isn't something that we fund directly, but so you've got a wide variety of titles you could use there. But if you want to do the things that are in one of these other classifications, then we also need you to be qualified for that. Bobby?
Would there be, is there a need to have three tiers?
Oh, somebody's.
Sorry. Or could you just group 1 and 2 as office support or paraprofessional or something like that, and leave the second as paralegal legal assistant? Or is there having 3 distinct required for some reason?
I don't think there's anything requiring that there be 3 tiers. We had originally set that up as a way of denoting that there is an exclusively administrative tier that's going to have a wide variety of things, and kind of a basic level of you need to have some before, if we are going to end up funding that tier, we need to know what this would entail and that there's some minimum qualifications in order to approve that kind of funding. I would hesitate to get rid of it just because there are going to be other roles within a firm that we may end up funding, and we need something to catch those. That isn't going to be covered by any of the other work groups either, right? So like, it wouldn't be under. This is kind of the catch all of the other administrative support, since interpreters, investigators, law students, and caseworkers wouldn't really click for any of those other general roles, if that makes sense. Amanda. Oh, you're muted.
I appreciate that question because it just sent my brain into that area as well, which is what we're, especially given Kevin's explanation about how, you know, people can call themselves what we want. This is just saying what people are going to be able to bill for in which category to OPDS. But I mean, I think it might be a great idea to just have 2 categories of support staff. One is billable and one is non-billable. We don't have to call it that, but I mean, basically that we're saying, what, you know, tier 1 support is all these lists of administrative, and then tier 2 is all this list of legal, whether or not we think of it as legal assistant, legal secretary, paralegal. What we're really thinking about is what would we, I mean, for me anyway, the way I think about it is, in my firm, would I be billing a client for this, or would this just be administrative, right? And that's kind of how we're looking at it in this document. That's how NALA's sort of looking at it when they're separating it out. So maybe it makes the most sense to not try to separate this tier 2 and tier 3, especially because we acknowledge in the document that these, just like Amy's saying, these roles are going to be in practice largely interchangeable. I mean, you know, people call, you know, I will call my paralegal, my legal assistant, a paralegal, even though she's really a legal assistant, because I'm trying to impress on somebody that she can draft a motion, you know. So I think maybe the semantics are less important of dividing these 2 sort of billable classes apart and just combine them into, this is, I think I heard the term paraprofessional, like this is a paraprofessional services, and we're going to define what the tasks are that you can bill for. And then these are the things that we see as really purely administrative, which are incidental to taking a case and representing a client.
Because I guess that, I think that's incredibly well said, especially because if the funding is going to be less for administrative, which would be considered overhead, and more for the billable, which is direct client services and representation and the point of our funding. I think that's a good distinction.
Okay. That, I think, fits to a degree about a lot of the other work groups that we have. So I I can reorganize this, and I'll split this. I'll split this into a second draft so that we have a couple of different options to look at as we're finalizing things, because I don't want to necessarily throw all of this away yet. But to that end, okay, so looking at this less of a okay.
I have something to add that might change your perspective, if you don't mind me sharing.
Yeah, go ahead. Yeah.
Okay, so how we view office support staff here and how I think it's viewed even in a smaller practice, because I worked in private practice as well, is we have the office specialist, right? So like that would be like your receptionist or intake or filing, the lower level legal assistant, tasks that might not require a lot of knowledge, maybe. I don't know. I'm not saying that correctly. So we have that's our first level. Then you have the legal assistant, and then you have the paralegal. So I don't know if maybe I missed something with the first meeting that, is there anything that needs to be brought up for like an office specialist? Because I know most agencies will have at least one office specialist to their, 3 legal assistants and 1 paralegal. And now the difference between the office specialist and like a legal assistant, there's a lot of difference. So like our office specialist, it primarily can only like answer phones, handle intake, filing. Like there's a lot of things that she can do, but there's a lot she can't do. So I don't know if we need to add that into these roles, because I do believe there should be 3 roles, but the legal assistant shouldn't be split into 2. I feel like legal assistant's 1, paralegal's 1, and then office specialist needs to be brought underneath the legal assistant, in my opinion.
So what I hear you saying is largely have the 3 tiers that exist, that are currently written. The low tier would be office specialist, office support staff, whatever we want to call it. The middle tier, legal assistant. The upper tier, paralegal. I will say, from a how do we qualify people standpoint, that is where the classification starts to become more relevant, because we want to ensure that people can start doing the routine stuff, even if they have not gone through a full training or a course or like a full paralegal program. And that's one way for them to have that professional development. So it's not just necessarily from a billables standpoint. And it may be that we're willing, I don't know what the legislature is going to be willing to fund. I don't know where some of this is going to end up, but it may be that we are willing to fund office support, office specialists. We've got, I think in our side of OPDC, I think we call them administrative specialists rather than office specialists, but it's the same basic idea, I think. Dawn?
So going back to our meeting the other day, and again, just to remind the people that weren't on, legal support for heart Investigations. We work with the attorneys, but we don't work for the attorney. But going back to what we discussed the other day, I think that's what you're saying is the different tiers break the qualifications down, because Oregon doesn't require you to have a bachelor's degree or any of this other. So, so for those of you who have invested in to get that title, it's more than just a legal assistant. Then if you don't have that separation, and I think this is what you were saying, Kevin, was that if you start off as legal support staff, you work toward going to that next tier. Well, if there's not a separation, you don't automatically become paralegal. So to have somebody that can put that says I'm a paralegal, but they don't have that experience, there has to be a tier. So I agree with Amy in regards to it's necessary, in my opinion, to have at least 3.
Amanda? Oh, muted.
I'm like butter. I just flow when I hear. I'm like judges I've seen. The last person that talks convinces me. But which is always a prosecutor. Damn it. I really wasn't thinking about it in terms of the qualifications, Kevin. And now, like hearing this kind of play out, I can see how. I do agree now. It is important to keep it separated because it's just like when you're qualifying at OPDS to do misdemeanors, and now you gotta have this qualification plus. In order to do juveniles, you also have to have this, and in order to do murder, right? So it's like this kind of progressive way that people can sort of, level up in the legal assistant paralegal world. And I would assume that one of the benefits of leveling up is, going to be related to the hourly rate that they get reimbursed for, right? So if you fit the qualifications for a legal assistant, you're going to get paid a higher rate than an office specialist. And if you fit the qualifications for a paralegal, because you've earned that through your experience and through your education, you deserve to be paid at a higher rate, even if the tasks you're doing are more legal assistant, just like attorneys. Those folks are going to do them faster. They're going to be more efficient. They're going to, so it's going to balance out. So I'm kind of now switching back to team 3 tier, although I do think it's important to just from, the discussion about what are the tasks that are billable, what are the tasks that are not billable. So I think it's a both and rather than an either or.
So I will say the question, sorry, just a quick interjection. I think the question of what's billable and what's not is probably not part of this work group. That may be something that we end up dealing with further down the line. And it may be this work group, just not in this, this context where we're developing the standards. That's, I think, similar to staffing ratios and things like that. Once we know that this is something that we will be able to fund, then we'll deal with the particulars of payment. Bobby, sorry about that.
All good. I 1000% agree of like people who have gotten their paralegal certificate or have done the additional training, whether that's in-house or whatever, might be at that higher, but in practicality or say internally someone gets those qualifications to now be considered a paralegal and they have a celebration, they get a raise, they get to update their footer. It is now that law firm going to OPDC saying, hey, we now have a paralegal, we need more money. Is that how it's going to work theoretically? Because it seems like that's more of a.
So in the space of attorney qualifications, that is currently how that works.
Yeah.
So long as you're not. So for hourly attorneys, it's slightly different. The hourly rate is based off of what type of case it is, not what the qualification of the attorney is. But for contract attorneys, it's what level are you qualified at, and that determines which of the 4 funding levels you're currently your firm or your contract is currently receiving.
Right.
And yeah,
but maybe it is not everyone going to hourly in a year and a half.
There's, oh man, I'm gonna have to remember some of the changes here. I'm trying to remember if there's a split. We're still allowed to contract with consortia at the next year's contract cycle, whether that's hourly or nonprofits. Yeah, we will continue to be able to, and that will always be not an hourly basis. The contracts with nonprofits will always be just I can't say that it's going to be the same type of contract we do right now. I know that we are also working on the workload model to determine how that all will work. I'm trying to remember whether everything is hourly in this upcoming cycle or the following one. But you are correct that at any rate, unless you're in a nonprofit, in 3.5 years, it's hourly, OPDC, or nonprofit. That's what I know for sure.
Which I understand is a bit in the weeds, but
yeah.
Yeah.
Okay. So at this point, I'm gonna shift this one to legal assistant and get rid of these two are synonymous language. And my thought process was when we get to the actual standards, defining in the standard itself which of the levels of which of the tiers it applies to. And then also noting in the role difference which standards apply to that particular role. Once we've listed those out and gotten them kind of more developed. Where we left off on Friday with qualifications, we had talked mostly about the bottom tier and the middle tier qualifications. Let me break this again. Okay. And we had not talked much about paralegal qualifications. So, what are people's thoughts on the basic qualification standards from NALA that we may want to add to? Particularly, NALA does not have a qualification standard regarding ongoing continuing legal education requirements or having recertification standards. At least I don't believe. I may have missed it. And then the other question that I wanted to highlight was whether we want paralegals to be subject to something similar to the attorney qualification standards as to which types of cases they can provide that legal work for, given that they're doing more independent research and client discussion and things along those lines.
So
go ahead.
My two cents. Oh, is somebody else? I'm so sorry. Amanda can go first. I'll wait my turn.
I think she's saying, go ahead, Amy.
Okay, sorry about that. So I have a hard time with this one just because because I'm a legal assistant and I've been in the legal field for almost 20 years. I have abundance of all of these skills, and I believe that they're transferable into the the paralegal position. And so I kind of struggle with the I guess in my mind, I think like because I have more experience than another person, maybe I would be more qualified for, larger cases like felony cases, or if you compare it to attorneys with misdemeanor and felony cases, I would imagine like somebody with more experience as a legal assistant or paralegal would have, maybe be able to be assigned to higher cases or higher caseloads. But I don't know that how I feel about adding that to the actual definition of this, because I feel like it's putting it more of like it's a standard now and we have to follow this standard. Whereas I think it should be based on each like agency or attorney law firm type of thing, how they feel about that individual paralegal or legal assistant, if that makes sense.
Okay. Any other input?
As a legal assistant, I absolutely agree. I'm sorry. I'm off camera. I agree with, I think it's Amy, because here, I primarily work on juvenile dependency, but I also work on murder cases as well whenever I'm needed. So it's a matter of your experience and what you can do. And, I don't think it should be, like I said, I'm spread across all types of law except family law that we practice here.
Amanda?
I just like it. So on the CLE requirements, I do think that some level of continuing education is important for this here. What I'm not sure what that would be, but I think that is reasonable to have some level of continuing education. I know that some nonprofits and offices do that, and some like with their paralegals, and some don't. And so I think that would be helpful. I don't think there should be a recertification requirement just because we don't have a one certification. We're like allowing different certifications. So I think that would be really difficult to track and enforce. But I do think that for the content qualifications, I think I agree with what the other two members said, and for me personally, we do so much different stuff in my office, and my legal assistant slash paralegal, Denise, who's also my sister, she, like, I think one of the keys for not having it be content specific is that unlike lawyers, these folks are not lawyers and have to be supervised by a lawyer. So if I'm supervising her, I know what her skill set is, what she can do, what she can't do, and what she needs training on, and what I'm going to give her more specific instruction on, and what I'm just going to leave her to her own devices on. And that's going to be different if it's a murder case or a dependency or a DUI. So I think that we should X the content specific, X a recertification, but maybe have more of a discussion about what continuing education should look like.
And that's kind of what I anticipated, especially when I was looking. I mean, in order for us to certify somebody for doing specific level of cases, there's a lot more that they'd anticipate doing. They'd be in court. They'd be doing the direct representation without. We do have certification under supervision, but the vast majority of people are doing independent representation. So makes perfect sense to me. I threw it in there as an option. Totally cool hearing everybody thinks that there are other ways to manage that instead. So cool. Okay. So what do we want to put in with CLE, continuing legal education, as a certificate? And I will note one point. I don't know that recertification would be as difficult to track. We don't currently require attorneys to recertify their qualifications. That is something that we are looking at. And when we do the revision to the attorney qualifications, which is one of the next phases of this plan. And we may look at recertification requirements for that. And we do have, at least in our current database, we do have a way of checking when the last certification occurred. Although it doesn't have the ability to currently flag people who have not had recertification in X amount of time. So that would be functionality that we don't currently have, but we could probably build in not too difficultly. Dawn.
Yeah, so I don't know. Do y'all go through DPSST or no for the legal support? Okay.
Nope. I think that's only for investigators.
All like first responders, so police, investigator, all that. So
for folk that we work with, I think it would only be investigators that have to go through DPSST, and that's not even. Okay. I don't think that's 100 required for everyone. In-house investigators, I think, are not required currently to go through DPSST, although I don't know that there's many who aren't.
Correct. Thank you.
So what other input for CLE requirements? And it may be that we don't consider this a qualification standard, but instead a performance standard. This is something that could go somewhere else either way.
I think it's important as a paralegal to have CLE requirements, just because there's, things are always changing. And I don't know what the NALA standard is on that. I was trying to read through, but I can't, it's not jumping out at me specifically, but I do think it is a good idea just to make sure that you're up to date on, you know, all the things you need to be, you know, doing. I think that would be a good idea. That's just my opinion.
I was looking at NALA standards too, and I don't remember seeing any particular numbers or things along those lines. The core competencies from NALA, which I sent out in the first email, does say maintain competency with continuing legal education, but it doesn't give any guidelines. For a benchmark, the Texas guidelines have 30 hours of CLE for your initial certification and 75 hours of CLE in the special. They do a content specific certifications, and you have to have 75 hours in that specialty area every 5 years for recertification. That seems a little high for me, but I don't know necessarily what especially since attorneys don't even have. I don't think it's anywhere close to 75 hours of CLE credit in 3 years. Bobby? Oh no, Dawn, I think you were first. Sorry.
I was just going to give you a comparison. For us, it's when you're a provisional investigator, it's 38 by the time you renew in 2 years. And then after you become a full PI, it's 30 every 2 years.
Bobby, I think you're next, right? Yeah.
Why not? A quick Google says attorneys have to have 45 hours in 3 years. But also then there's a question of who's paying for that. Is the firm paying for that? Is the paralegal paying for that themselves? Because I could see a world in which attorneys are like, well, we'll just call you a legal assistant and then we don't have to pay for your CLEs. Or is that funding wrapped in from OPDC to that position?
That is a fantastic question. To my knowledge, OPDC does not currently pay attorneys explicitly for the purpose of attending CLE.
Exactly.
At all. And I don't think, I think that's any state employed attorney, that's the same, it's the same thing.
Right. Yeah.
I mean, in my experience, that's not the same thing. It's another example of how unfair the system is, because when I was the attorney in charge at the Department of Justice, we paid for all the CLEs for everybody, and the same thing at the U.S. Attorney's Office, even if that meant sending you to Hawaii, pay for your airfare and your hotel and everything. So I mean, I'm not aware of any government law office that's not paying for CLEs. But that said, I think that is kind of like a side issue that probably this group isn't going to be able to totally address. I think that we should stay more focused on what do we think whether it's the qualifications or whether it's the standards for a paralegal. Do we think it's important that they have continuing education? And then there's probably another discussion to have about funding. But yeah, right now in the world of public defense, attorneys are typically paying for those things. And so I don't, I mean, I think without something more being said, it's going to be up to the individual firm, nonprofit, and staff how that is worked out in their negotiations.
I have something to add to this, because
sure.
I don't know this, and I'd like actually maybe somebody who does have their paralegal certification, or actually in general, if we're hiring somebody without their paralegal certificate, so I myself am not, I don't have my certification, but I am qualified as a paralegal from previous work and whatnot. And I come on to a paralegal position here, and now it's saying I need to have all these CLE certifications. Can I go take those certifications without having my paralegal certificate? Or how do I become a certified paralegal if I haven't gone through an actual course? Does that make sense? Because if you're requiring everybody to do CLEs as a paralegal, and they've come on as just 3 years of law-related experience or 2 years of in-house paralegal training, they're not technically certified with NALA. Are they still essentially qualified to be able to take these CLEs?
Yeah, sort of piggybacking off of that, am now hesitant to require that. Like if somebody is required to do that to keep their NALA certificate, I almost think that should be a separate from the OPDC CLE requirement for, yeah, those reasons.
That's a good point. How do we want to handle, okay, so I'm trying to think if I've seen, not that I know everybody who's ever attended an OCDLA conference ever, because that would be impossible. I tell you what, I will see if I can reach out to, I don't think that there would be a problem for, actually, I wouldn't be surprised if OCDLA actually has something on. So I'm going all over the place here, but this is good because this is a great question. OPDC is working on trainings for attorneys and for core staff roles. So this may be something where we provide the CLE ourselves. And I think we are anticipating that any of the CLEs that we create are likely to be free of cost for those taking the CLEs. Now, that said, they are anticipated to be designed as trainings, not as CLEs. They are different in purpose and different in kind of what they're approaching. But it may be that those would still fit the same thing. I want to say this is super early in our planning process for those things. So all of this is subject to change because none of this is finalized yet. I want to say that OCDLA actually allows, I don't think they have any problem with any kind of legal support staff being at conferences. And that would certainly be part of the where you'd be able to gain those. But I'm also hearing that is still potentially something that would be difficult for somebody to meet, depending on the route by which they become qualified and certified. This is certainly something that we want to treat pretty carefully. Let me see if I can find.
I will say quickly, Kevin, circling back to Amy's question a minute ago, we had previously had a legal assistant who worked for our family law department. She attended conferences and CLE classes without being qualified or certified as a paralegal. And she actually attended with the attorney for the family law conference every year. So I don't think it's a requirement for at least things that are offered through the bar.
And I know, so I just pulled up OCDLA's, the juvenile law conference is, I think the next one, it might be something else coming up first, but in any case, juvenile law conference is coming up and they do have a non-lawyer rate for the registration fee. And I assume that part of the difference in that rate structure is because of the having to go through and get certification from the bar for CLE attendance, which does, the bar requires some money for getting that attendance credit. Amanda.
And then I guess, so,
sorry,
I just interjected myself. Who is then collecting that? Because when attorneys take their CLEs, they submit it through their bar membership online. So then who is collecting and counting and authenticating those CLE credits that these paralegals are now required to do?
That is a fantastic question that does not currently have an answer. We could write an answer. That could be a part of it, and it may be something that we want to consider as part of this. Something I'm going to definitely want to bring up with General Counsel before we impose that requirement. Amanda. You're muted again.
I was unmuted and I just muted myself. Sorry for my ADD, guys. I know this isn't like totally on point because it's a side issue, but just so we're all clear, they're now in Oregon, we have licensed paralegals, right?
Yes.
And so there's a track that the bar has where they do require CLEs and it's just like attorneys, right? So for licensed paralegals, that's not necessarily what we're talking about, although you know, certainly there are going to be offices that do DOMREL and have licensed paralegals and also do criminal, you know, right? So there could be some overlap there as well. But I would just say, kind of to follow up on Kevin's on the job research onto the OCDLA website, it's my reporting year right now, so I'm intimately familiar with this, with CLEs that are available at low cost or no cost online that are related to criminal law practice. And I can tell you that for OCDLA, for the PLF as well, and the Oregon State Bar, anybody can do those CLEs. There's no requirement. I mean, you don't have to be a lawyer. You don't have to be a licensed paralegal, right? Anybody could do them. The issue of tracking, I guess, is different. I mean, maybe initially when we first rolled this out, it would be on the individual like we used to do before. I don't know if anybody's as old as me, probably not, but we used to have to track it ourselves and save all of those documents and have our little CLE forms that we kept in a paper folder, and then, you know, fill in it all in every year and report it to the bar. So maybe initially it would be on the individual to track their hours and report how they met them. But there's a lot of CLEs available online for low cost or no cost through PLF and OCDLA and the bar that are directly relevant to paralegals and legal assistants, even if they're not just the substantive ones, but the ones about drafting motions and, you know, doing research online and, you know, all of those practical skills CLEs on the PLF website. As I've been meeting my requirement, I've been sending them to my legal assistant saying, would you please watch this? So yeah, I think it probably won't be too challenging for people to find those resources and be able to participate.
Yes. Okay. So additionally, it should be noted that we do currently, under the contracts for public defense services, we do require CLE credits every year of the attorneys who practice. However, we don't track that in any way either. That may change under future contracts. There may be some process that we build. So it is not, shall I say, it would not be an issue of first impression to have a requirement that we don't actually track. So not sure that's great, but it is what it currently is. So, so to that end, have we reached a consensus on whether to have a CLE requirement? And if so, what is the requirement? And I'm going to see if I can find the OSB licensed paralegal CLE requirement.
I think if we're taking a vote, my vote would be to not have it. I think if people have paralegal training that requires it, that's a separate thing. But I think for these purposes, I would vote not to have a CLE requirement.
Okay.
I'm with Bobby on that one, just because of the fact that if we're hiring from like just personal experience and working your way up from a legal assistant to a paralegal that doesn't have the certification of paralegal, I don't understand why we would need that in this, you know, in what we're doing right now. I think it's great. And I think at some point later down the road, maybe add something, but I don't see it that it is important to have as an actual requirement to become a paralegal with the state agency or with a private law firm.
Okay. Would this be something that's okay? So and Dawn.
So my question is, I guess I'm thinking of it from a different way, in regards to, you know, you have the position, and, you know, as someone mentioned, everything changes all the time, especially in legal. To continue education, to encourage people and hold them responsible for growing. You don't want to have someone that doesn't have the ambition to improve. So that's the way I'm thinking about it. It's like, why would you not want why would you not want them to be responsible for growing and developing?
So then would this maybe fit better as part of the supervising attorney's responsibility or oversight of the paralegal and providing them access to CLEs relevant to the work that they're doing?
Yes.
Amanda
Sounds-
saying, okay.
I don't, here's the problem I have with that. So for really small offices and sole practitioners, I anticipate that there's going to be people who, once, if this gets created, we're going to start seeing people using treating paralegals and legal assistants the way that we work with investigators. So you might not have somebody working for you in your office, but you might get a murder case and then say, oh, who's on the OPDS qualified list for paralegals? I need somebody. Or maybe like for me, I just have one part-time legal assistant, but I might want to get a paralegal for this murder case that I'm doing. And then I go hire Amy, who left her office and is out freelancing. And I'm like, please, I know you're awesome. Come work with my team and show us how to do this trial prep, right? So I don't think it should be up to the attorney because that assumes that people are only working in one office with one lawyer. I agree with what was just said, though, about I think we want to keep people up to date and pursuing getting better and more knowledge, and just like attorneys. And I think Amy mentioned before, like everything's changing all the time. We need to have people that I just think like it scares me that people aren't getting if people aren't getting continuing education, like what does that even mean? So I don't know, maybe there could be a difference between when you, like, if I become a lawyer, I don't have any CLEs, I just got sworn in, but every year from here on out, I've got to keep my requirements. So maybe it's not a requirement to get the contract, but once you're in this, you need to, just like investigators, just like lawyers, keep up with this, whatever we decide is reasonable, 10 hours a year CLE requirement or whatever.
My thoughts exactly. That's what I was trying to say. Like, I don't think it can be a requirement to get the position, because then you're basically need to take 6 and 7 out, because if you have 6 and 7 there, you're basically saying you don't have to be a certified paralegal to have this position. But I do believe, yes, we should definitely be continuing our legal education throughout the time, with whatever specialized area we are in,
Okay, so tell you what, let me check with KO, who is leading the investigator work group, and see how their group is handling ongoing education requirements. And if it is just like, all right, one of the performance standards is keep up to date with by taking CLEs, and we can make that just a loose requirement that doesn't necessarily need to have a defined number. Maybe that's sufficient to ensure that we've got that base covered. Does that make sense? Okay. Dawn?
So I can answer to that because my husband is on that board.
Fair enough.
So you can get your license to become a PI. Okay. You pass the test, you get the PI license. And then, as somebody mentioned, and then that's your requirement. So over the next 2 years, you have to get those CLEs. They're very easy to get. They change it to where, you can listen to podcasts, you can, go to seminars and such. However, what it's not enough to have somebody take an open computer test and then make the same thing that, for example, my husband, years of law enforcement, years of experience, for that person to walk in off the street and make the same amount of money as he does. Whereas we run an agency and we make the same as, Joe Blow from off the street. So they're looking for different qualifications because we're dealing with people's lives And for somebody who went, oh, this will be a cool job, to give them a murder case, it's scary that there is no qualifications for that. So it's, it tickles me to hear y'all talk because, y'all are on a whole nother spectrum than we are. But that, you want people to be qualified. You want people to learn. You want people to grow. And speaking from my experience, again, I'm on the other side. There has not been any responsibilities to take care of our clients. We're supposed to be defending them, but if we don't know what we're doing, it's kind of heartless to allow people to do that. So anyway, I'm sorry, I could talk about this all day. I got chills. But yeah, so there are no qualifications. You can get your CLE by subscribing to a magazine, and that's just not enough in our opinion. We think it should be more education and more, we always tell people it's a passion job because Lord knows that we don't get paid much for it. So anyways, I'm sorry, I'll shut up now.
No, I think it's a good point. That is one thing that, we have standards for who can take murder cases. But somebody can walk into any private law firm and hire somebody to take a murder. And if that attorney just passed the bar, congrats, technically they're, as long as it's not public defense, they're technically qualified to take that murder. They probably shouldn't. And I would hope that they, keep in their mind that maybe this is beyond the first year associate level. However, now that all said, all of the work in this, like in the scope of what we're talking about, would be under the supervision of an attorney who is certified and qualified by us to do specific levels of cases. So hopefully that judgment would also, kind of move towards, okay, so who do I want working on this case? And do I know that they are ready to handle this level of case as well? I want to raise up that it is 12:08. We are 8 minutes past when we said this group would be finishing. I'm happy to continue with anybody who wants to, but I also know that everybody has very valuable time. And so if anybody needs to leave, by all means. We're technically at the end of today's session, but we can keep going if people would prefer to do that.
I'm good to keep going if we need to, or reschedule another meeting or whatever, but I just wanted to close the loop on that, on just this discussion, and obviously jump off, don't listen to me talk, but because Kevin, right before, so I had heard you say maybe we just kind of leave it as a practice standard, but don't specify it or make it like a hard requirement with hours that are tracked. I think we should have hours. I don't think we should just say get continuing education, because if we say that, everyone's going to say that's not a real thing. We don't have to do it. Like, what does that even, it's just too vague. I think that we should say, whatever. I mean, I think 10 hours a year is easy, reasonable, doable, less than what investigators and lawyers are required. It may be just a starting point and it could go up from there. But since it's a new thing, maybe 10 hours a year, and just say, you can self-report. We're not going to police you about it, but we're just going to ask you to certify that you've done 10 hours of CLE. They can be online. They can be whatever all the lawyers do. Whatever counts for us will count for you. And I also think that if you build it, they will come kind of thing. Like, if this starts to be a requirement, I think you're going to see consortiums of lawyers and independent solo practitioners, people that are in the defense community, and you'll see OCDLA jump onto it too and say, we're going to provide these resources for specifically targeted to paralegals and legal assistants for what the lawyers think that it's important for you to know in criminal defense trial world, right? I think it'll just elevate the practice for everybody.
Okay.
I agree with that, Amanda, because, and so like that being said, like it's not like requiring it to become a paralegal, but when you become a paralegal, you need to get X amount of CLEs, which is so true. Because I personally think that even on the appellate side, like, I mean, we do get to go, we have some trainings over here, but like, there is so much to be learned in like any area of law. And I think that like, I guess making it mandatory that the legal staff is it too should be continuing their legal education. I just had a problem with it becoming like being like you have to be a certified paralegal to become a paralegal. Like I had a problem with that.
And I should say that wasn't my intent. I wasn't intending to have the CLE requirement be before hitting that level. I was meaning for that to be like an ongoing after you've hit that level. Is there any, since we're talking about this, do we, and I was not anticipating that this would apply to the middle tier, any CLE requirement would apply to the middle tier at all, given that that tier is intended to be very routine documents that don't need any real legal analysis. I'm getting a lot of head nods, so I feel like that there's pretty solid consensus on that. Okay, cool.
And I think, Kevin, just to
go ahead.
To interject one little thing, I think it is important if we're requesting funding for a paralegal position, that we have a responsibility, to keep our skills up in order to, receive that funding. So I think it should be a requirement. And I haven't had to track CLE since I've been in Oregon, which is a while. But when I was in Georgia, I want to say it was under 20 hours a year that we had to complete, and it was maintained by your firm or yourself. Mm-hmm. There was no necessarily reporting it officially.
So you might be subject to audit at some point, but not necessarily a proactive reporting requirement. Okay.
Right. And here, my partners do keep track of what we do. Mm-hmm. So, yeah.
For context, the OPDC contract for attorneys currently requires 12 hours of CLE per year of the type of practice associated with your contract. Let me double check that I've got that right. I think it's 12 hours per year. Yeah, 12 during the contract period. So every 2 years. Over the course of the 2-year contract, 12 hours CLE credit. So that would be 6 hours a year for the attorneys as a reference point to where we might want to put the paralegal CLE standard.
Well, I think that's a little different because attorneys have to report 45 hours to the bar every 3 years. So when OPDS put that in there, they're saying of the 45 hours you report, 6 hours a year have to be specific to your contract area.
Right.
But paralegals under this, like they're not required currently. Like my assistant isn't my paralegal's not required to get any CLEs to work for me. So this would be all that they're required to do. I mean, I just throw that out there. In terms of the practice area, I just think it depends how narrow it is. I interpret what the state is saying to lawyers with that 6 hours a year is, I need you to get 6 hours a year of juvenile or criminal, CLEs. And I would say that for my expectation of a paralegal, I would want them to, it's great if they get the practice area, but also what I'm more interested in is them getting CLEs on motion practice and filing rules of evidence and civil procedure and the things that are changing all the time, that there's what they're going to be doing. Like I'm going to be the one that needs to know about the substantive law. They're going to need to know more about the rules and the procedural law. Because frankly, I'm not an expert on that, and I expect my paralegal to be. So I would just be careful about making it too specific into like practice area. But I think 6 to 10. I mean, I don't know.
Other thoughts?
I don't have a comment on this, but I wanted to let you guys know I have to go and deal with a prelim now. So thank you all. I look forward to seeing you on the next one.
Okay. I think we're starting to lose folk, so it may be a good stopping point at this point. So I think so I'm going to send out a doodle poll again for the next session. And my hope is that we can tackle performance standards at that point, since I think we've nailed down the qualification standards. Okay, cool. I will work this up into a further draft, and I think we're good to go. Awesome. Thank you, everybody. I really appreciate everyone's time on this.
Thank you.
Thanks for your work, Kevin.
Yep.
Yes,
All right.
definitely.
Have a great rest of your day. Bye.
Bye.